Welcome everyone. This is a series of lecture on evidence law, and today's lecture will be on relevancy of facts under the Act. Till now we have discussed what is Evidence Act basically and what are the important definitions given in the Act. Now we move on to the relevancy of facts. So Section 5 basically provides for the relevancy of facts. Evidence, it says that evidence may be given of facts in issue and relevant facts. It may be given in any suit or proceedings of the existence of non-existence of every fact in issue and of such other facts as hereinafter declared to be relevant and no other. This section shall not enable any person to give evidence of fact which he is disentitled to prove by any provision of the law for the time being enforced relating to civil procedure. Chapter 2 of the Evidence Act 1872 deals with the topic of the relevancy of facts, and it is the hub and fulcrum around which the entire scheme of the Act revolves. This chapter determines the rules on the basis of which the court considers certain facts as relevant for the trial of the civil or criminal proceedings. The purpose of these rules is to ensure that the time and effort of the court are not wasted on matters which are not material to the inquiry. The attention of the court and the parties should be focused on material facts which have relatively a high probative value, and the parties are put on prior notice regarding what they should adduce as evidence in the court of law. The Evidence Act deals with issues relating to relevancy by focusing attention on only on fact and issue and relevant fact. According to Sir James Stephen, the most universal rule of evidence is that evidence adduced should be alike directed and be confined to the matters which are in dispute. Anything not directly connected is irrelevant. That is the collateral fact. Section 165, which confers on the judge enormous power to elicit the truth by putting any question, relevant or irrelevant at any time, of any witness, in any form, or order production of any document, still mandates that the judgment must be based upon facts declared by this Act to be relevant and duly proved. Here, duly proved means proved to the satisfaction of the court. Section 3 does not really define what is relevant, but only says that facts declared to be relevant in Section 6 to 55 are relevant. Section 5, which like a waymark or signpost directs, go this way, which provides that evidence may be given of every fact in issue or of such other facts as are hereinafter declared to be relevant. Now we can look at the term relevancy from two perspectives, that is one logical relevancy and legal relevancy. Before getting into that, we should know the meaning of relevancy. According to the dictionary meaning of the term relevancy, the relation of something to the matter at hand, or which is pertinence, connection, or materiality. These are the terms we can connect with the term relevancy. If one factor is connected to the other logically, it is called logical relevancy, and it may be based on the following factors among others. For example, cause and effect, occurrence at the same time, occurrence at the same place, common purpose and for instance, if a severed dead body is found on a railway track, it can be inferred that the death occurred because of the train running over the person. On closer observation, it is found that there is no hemorrhage near the body. The first inference may be replaced by another inference that the person was killed elsewhere and the dead body was thrown on the railway track to create the misleading impression that he was run over by the train. Here, the inferences are drawn on the basis of logic based on cause and effect. If two or more persons have committed an offense together at the same time and place, it may be inferred that they were acting with common intent. Now, the coming to the legal relevancy, while logical relevancy is certainly a very important factor in determining the probative value of facts, it so happens that the facts may be connected to each other by varying degrees of logical proximity, Thus, for instance, there may be direct, proximate, and immediate cause and effects, and remote, indirect, and even conjunctural cause and effects. Here, hence, the court should let in only those facts which have a high degree of probative value that would help the court to decide one way or the other with relatively greater certainty. Then the next question that arises is, how far is too far and how close is? We can say that all facts which are logically relevant are not legally relevant. One fact is said to be legally relevant to another only when one is connected with the other in any of the ways referred to in section 6 to 55 of the Act. Whatever is legally relevant is logically relevant. However, only legally relevant facts are considered as relevant fact. For example, a confession made to police officer may appear to be logically relevant, but it is not legally relevant. For section 25 of the Act declares that it cannot be used as evidence against the person making it. The question of relevancy is a question of law to be decided by the judge. If irrelevant evidence is so mixed up with relevant evidence that it cannot be separated, the whole of the evidence should be rejected. The question of relevancy is a question of law and can be raised at any stage of the proceedings. Consequently, the Evidence Act 1872 adopted the device of declaring as relevant in section 6 to 55 only those logically connected facts which are considered to have a high probative value. Thus, facts which may be connected to each other so remotely that they cannot be considered to have high probative value are kept outside the purview of the provision of section 6 to 55. Facts legally relevant under the Evidence Act means simply facts declared to be relevant under the Act. And this is a part of the legislative and not judicial determination. Hence, all logically relevant facts are not legally relevant, and all legally relevant facts may not be logically relevant. For instance, the Evidence Act permits impeaching the creditor of a witness by injuring his character, even though his character is not logically relevant in the fact in issue. That's all for today. Thank you.